Hi everyone, welcome to this month's Facebook Live. This is Carrie Payne on behalf of the Art of Estate Planning. We've got a really exciting presentation today, the taxation of deceased estates with recent developments, tax traps and tips. It's the 13th of July 2023 and I've got two very wonderful ladies joining us. If you'd like to introduce yourself, ladies, and your law firms and a little bit about you.
So, hi, thanks for that, Carrie. My name is Archana Manapakkam. That's a bit of a mouthful, so you can call me Archie. I'm a special counsel in the tax team at Velocity Legal, and sort of the areas in which I practice SMEs, high net worth individuals, private wealth structures, and I do a broad range of tax advisory and tax dispute resolution work. So that's a bit about me. I'll hand it over to Katerina.
Hi, thanks for having me, Carrie. Katerina Peiros. I run a little boutique practice down here in Malvern in Victoria. And we just do wills, estate planning, incapacity work, estates, litigation. Thanks for having me on the show.
No worries. So just before we get into sharing the slides, we've got some really interesting content. If everyone can let us know if you're here, where you're dialing in from, so to speak. I don't know if dialing is the same term when you're online, but post a comment so that we know that we're out there and we're playing to people. In the meantime, Archie, do you want to take it off? If you go down to the presenter mode there for your slides.
Very good.
Off we go.
Here we go. So thanks for coming, guys. So we are, the topic, as Carrie said, is the taxation of deceased estates. We'll be looking at recent developments, tax traps, and tips. So in terms of how, what we're going to cover today, so I'll be doing part one. So that's looking at the tax aspects of deceased estates, tips and traps. So I'll be looking at the legislation and some practical aspects of that. And then part two will be presented by Katerina. She'll be looking at some case studies and some recent cases. So without further ado, let's get started with part one. So I've got 7 tips and traps here. And the first one that I'm going to cover is deeds of family arrangement. So just a little bit of an overview before we get to this particular tip. The CGT rules provide for 2 key exemptions in connection with death. So the first exemption is that any capital gain or loss arising from death is disregarded. And the second is that any capital gain or loss made by an LPR of a deceased estate, so that's a legal personal representative, being either an executor or an administrator, any capital gain or loss that they make will also be disregarded on the passing of an asset from the LPR to a beneficiary. And the ATO administers the law in the same way in respect of an asset passing to a trustee of a testamentary trust, as well as from the trustee of a testamentary trust to a beneficiary. So in terms of the passing of an asset from an LPR to a beneficiary, when will that rollover apply? So the definition of passing is actually defined in the legislation. This is Division 128 of the 97 income tax legislation for those who are interested. Now, with the deed of family arrangement, there are 2 sorry, bear with me. The important thing with the definition of passing is that any consideration that the beneficiary gives must be limited to a variation or waiver of a claim to one or more CGT assets forming part of the estate. If anything else comes out of the estate, then it won't be eligible for the rollover. So that's really important to bear in mind. And it's also important if you've got land to confirm the stamp duty position as well. So I know we've got attendees from a number of different jurisdictions here today. So I'm not going to go into too much detail. Just for I can say for Victorian purposes, the transfer must be in conformity with the terms of a will or with the trust, in conformity with the trust created under a will or arising on an intestacy to be exempt from duty. And that's the ATO, the SRO applies different approaches depending on whether there's a will and whether there's a specific gift identified under the will, or whether there is an intestacy. So there is a revenue ruling on that, and I'll leave you guys to have a look at it. So that's deeds of family arrangement for you. The second thing that I want to talk about is later acquired assets by a legal personal representative or a trustee of a testamentary trust. So it compromises, if you've got, for CGT purposes, there's no rollover on the passing of an asset from an LPR of a deceased estate or the trustee of a testamentary trust in respect of a later acquired asset to passing of that asset to a beneficiary, as it only applies to assets owned by the deceased just before dying. So this is the rollover in Division 128. So for example, if you have later acquired shares under a dividend reinvestment plan, that will not qualify for the rollover when that asset is actually passed to a beneficiary. And there are a number of CGT events that can be triggered there, which I won't go into detail during today's presentation. Suffice it to say that the rollover will not apply. It's also important to consider how the impact on the accepted trust income rules. So this is relevant if you have minor beneficiaries. So for accepted trust income, broadly, ordinarily distributions from trusts to minors are taxed at special rates, which can be up to 66%, but usually it's at the top marginal tax rate plus Medicare levy. However, if it's accepted trust income that's going to minor beneficiaries, then the minor is taxed as though there are an ordinary adult marginal tax rates. So that with the benefit of the full tax-free threshold. So that's a real benefit, but it needs to be accepted trust income for those rates to apply. And for accepted trust income, when it's income coming from a trustee of a testamentary trust, it needs to be income derived by that trust in respect of an asset transferred to the trustee from the deceased estate, or property that represents accumulations of income or capital from that property. So for dividend reinvestment shares, say acquired under dividend reinvestment plans, that's okay because that's in terms of accumulations. But if it's anything that comes outside, so if it's later acquired assets from borrowings, or if it's there are two spouses and a testamentary trust is set up under the will of the first spouse, second spouse passes away, and then a gift is made from that spouse to the testamentary trust of the deceased that passed away before, then that won't be accepted trust income, and the minor beneficiary will be taxed on that income at the top marginal tax rate, plus Medicare levy. So that's that in terms of tip 2. The third issue that we're going to be looking at is foreign resident legal personal representatives and trustees of testamentary trusts. So this is a tricky issue. Now, there are various adverse tax consequences if you have a non-resident estate, and Katerina will discuss what some of those are. And those broadly relate to things like, if you have assets that are not taxable Australian property, so you might have shares in ASX listed companies. It can be that when you have a non-resident estate, the rollover won't apply when the asset passes from the non-resident estate, the LPR of the non-resident estate, to a beneficiary. even if the beneficiary is not a resident. And there's also issues in terms of the 50% CGT discount. So apologies, it's not the rollover, it's in terms of the 50% CGT discount. There will be some, Katerina will discuss that when she comes to her case studies. But in terms of residency, generally you'd want a resident trust estate. And you will have a resident trust estate if there's at least one LPR or trustee who is a resident at any time during the income year, or if you have central management and control in Australia at any time during the income year. The easiest test to meet is that you have at least one trustee or LPR who is a resident of Australia for tax purposes. Now, there's an issue if you have a testamentary trust. What if you use a corporate trustee instead of a non-resident individual? If you have a corporate trustee that's incorporated in Australia, then that will mean that the testamentary trust will be a resident trust estate for tax purposes as well. So you'll avoid those adverse consequences. Now, if you have a will that names a non-resident as a sole executor, in order to avoid the issues of having a foreign resident estate, it's better to apply for letters of administration with a resident administrator with the will attached, so that the trust will be a resident, the trust being the trust created upon, in terms of the deceased estate, which is also regarded as a trust, to ensure that that is a trust for tax purposes. So that's point 3 I have. Point 4 up on that slide is where you have beneficiaries who are tax advantaged. So by that I mean foreign resident beneficiaries, tax exempt entities other than deductible gift recipients, and trustees of complying superannuation funds. Now, what happens in that circumstance is that a capital gain is triggered upon death in respect of assets that are not taxable Australian property. So things that are generally not land in Australia. So things like shares in ASX listed companies. Now, that gain happens when the relevant property passes to the non-resident, for example, or other tax-advantaged beneficiary, but it's reported it's treated as having occurred just before the deceased's death. So it needs to be reported in the deceased date of death tax return. There may be some time lag between when the asset passes and the date of death. Now, there's an amendment period that applies for date of death tax returns. It's usually 2 years, sometimes it can be 4. So if the asset passes after that amendment period, then the gain effectively falls through the cracks and it's not reported anywhere. So, but it is important to bear in mind that if you have a tax-advantaged beneficiary, you can have a CGT issue in respect of assets that are not taxable Australian property. And in those circumstances, it's better to sell the asset in the estate and distribute the proceeds, and for example, claim concessions rather than distributing the asset in specie to the beneficiary.
Archie, just before we move on, someone's had a question just to give you a bit of a break, so you've got a chance to have a breather.
Let me have a look.
No, you're good. I can read out the question to you while you have a bit of a breather. Jennifer has.
Yeah.
Jennifer's asked whether income from replacement assets is still accepted income. So for those that are newer to the game than Jennifer and Archie are, when you sell an asset of a testamentary trust and buy a new asset with it, and that asset then produces its own income, Jennifer's asking whether that income that's produced off the new asset is also accepted trust income.
I believe it should be. I will have to double check that. It'll still be a problem for the purposes of CGT when the asset eventually passes to the beneficiary.
Yeah.
But I'll have to, I will take that one on notice. So who asked the question?
Jennifer Jackson. So Jennifer's
Jennifer.
one of our family members in the TT Precedents Club. So we have an
Yeah.
ability, Jennifer. We might take that one offline and come back to you.
I think that it should be considered an accumulation, and it should, but I'll have to double check. Property representing accumulations of income or capital from property that satisfies, yes, I'll have to take that one on notice, Jennifer. It's a good question. Those rules are quite tricky.
Yeah, I think Tara's mentioned here, which is what we think is the general understanding, that if you can trace the sale proceeds to being reinvested in the new asset, it should be. There's obviously some grey areas when you can't do the tracing. So
yeah, I suppose because it does originate from the assets of the deceased estate.
Yeah.
So you got whatever it may be, and then you sold it, and then you've reinvested it. But again, there is a problem in terms of the CGT position there.
Yeah. Excellent. All right. Sorry to interrupt you, Archie. Just
Question.
thought I'd give you a
that's
break.
all right. No, it's good. Just break things up. I don't want to be delivering a monologue here.
I'll throw back to you now, Archie.
Okay, very good. We'll keep going then. We'll push forward. Now, concessional taxation. So normally when you have a trust, anything accumulated in the trust is taxed in the hands of the trustee at the top marginal tax rate. However, when you have a deceased estate, concessional rules apply. So for income tax purposes, a legal personal representative is assessed as though they're a resident individual for 3 years. That's really good. It means that they'll be assessed at ordinary resident adult marginal tax rates, and it also means that if any assets are disposed, the LPR can actually access the 50% CGT discount in respect of any assets that have been held for more than 12 months. With an ordinary trust situation, you won't have that. That's the income tax position. It's also important, if you've got land, to consider the land tax position. Again, I'm conscious that we have attendees from a number of different jurisdictions here, so I don't want to go into too much detail about it. However, for the benefit of the Victorian attendees, I can say, being Victorian-based practitioner, that in Victoria, the concession is also for 3 years for land tax, with a discretion to extend that period. So the land tax surcharge rate that normally applies to land held in trust will not apply for those 3 years. And in respect of a principal place of residence, there's a PPR concessionary period of 3 years as well, where that property won't be taxed, subject to land tax. So that's number 5, concessional taxation. Number 6 is an interesting one, and that's in respect of accessing the small business CGT concessions by an LPR, beneficiary, surviving joint tenant, or trustee of a testamentary trust. So say, for example, that the deceased carried on a small business. Maybe they had a farm, and they had some farmland that they used in that farm. Now, what happens is that upon death, these individuals, the LPR, the beneficiary, so forth, as set out in that slide, will stand in the shoes of the deceased. And if the deceased was able to access the small business CGT concessions, they will also be able to access the small business CGT concessions on a disposal of any land, any assets used in that small business for a period of 2 years. So if it's disposed of within 2 years, then that can be accessed. The commissioner does have a discretion. That's the commissioner of taxation does have a discretion to extend that period. So for those, hopefully most people are familiar with what the small business CGT concessions are. For those who aren't, It's basically a bunch of concessions that are available if you for taxpayers that carry on a small business, essentially, and that's defined in terms of turnover as well as a maximum net asset value test. Now, it's important to bear in mind that the deceased needed to actually have been able to access a small business CGT concessions if they had been alive and they had disposed of it during their lifetime, which means that if you had a pre-CGT asset, you wouldn't be able to access, the deceased wouldn't have been able to access a small business CGT concessions in respect of a disposal of a pre-CGT asset. That's one that was acquired prior to 20th September 1985. So that means that the LPR beneficiary and so forth will also not be able to access it. Now, ordinarily, that doesn't present too much of an issue if the asset is actually disposed of, so say farm that's used in a farming business, shortly after the deceased date of death. And that's because upon death, the LPR beneficiary, so forth, will get a market value uplift. I'm getting very technical here, but basically capital gain is calculated as the difference between capital proceeds and the cost base, basically generally considered the acquisition price. However, upon death, what happens is that with a pre-CGT asset is that the LPR beneficiary will basically be deemed to acquire a cost base that's equal to the market value as at the deceased date of death. So if the LPR beneficiary, so forth, disposes of it shortly afterwards, any gain in the interim will likely be minimal. However, if you wait for a longer period of time, there might be considerable movement in the value of that asset. Say if if it's farmland and then it gets rezoned and it's now within the urban growth boundary, or however else it might be rezoned, it might spike up in value. That means that any gain that's accrued since the date of death and the actual disposal will actually not get any, not benefit, but will be taxable, essentially. I know that's quite technical, but hopefully you guys do follow me, and I'm happy to take questions offline on this point as well. And the final one that we're going to talk about is near and dear to everyone's heart, and that is the main residence exemption. So the main residence exemption is actually very, very complex. There's a lot of nuance to it. And the one that we're going to look at is the main residence exemption upon death. And for those who are interested, that's set out in section 118-195 of the Income Tax Assessment Act 1997. So there is a difference between a pre-CGT dwelling and a post-CGT dwelling. So that one that was acquired prior to 20th September 1985 and one that was acquired on or after that date by the deceased. So for pre-CGT dwellings, there's no requirement for that dwelling to have been the deceased's main residence just before their death, and there's no requirement that it not be used for the purpose of producing assessable income after the date of death, so it can be rented out. You can still potentially get the main residence exemption. That's an LPR, legal person representative, or the beneficiary can still potentially access the main residence exemption, even if it wasn't the deceased main residence, and even if it was rented out after their death. That's for pre-CGT dwelling. For post-CGT dwelling, however, it needs to have been the deceased main residence just before their death, and it can't have been rented out in the intervening period between the date of death and the disposal. Now, for post-CGT dwelling, the second dot point, all is forgiven. So it means that even if the main residence, the dwelling, wasn't the deceased main residence for all of the ownership period, it doesn't matter. If it was the deceased main residence just before they died, then you're okay. Now, there are additional requirements that need to be met. So that part is, when it was acquired, whether it was a main residence of the deceased, and whether it was used for the purpose of producing assessable income after their death. The second part is that either the property is disposed of within 2 years of the date of death or within such further period as the Commissioner allows, or it was after the deceased's death, the main residence of a spouse or an individual with the right to occupy or a beneficiary. Okay, but there's no further 2-year period after it ceases to be that person's main residence. In those circumstances, if it was, say, disposed of within 2 years, it's exempt from CGT. It's the main residence exemption applies to that disposal. And if it's disposed of after it's the main residence, or just after it ceases to be the main residence of the spouse or individual with the right to occupy and so forth, it's also exempt. Now, in terms of within such further time as the Commissioner allows, so that's 2 years, there is a PCG on that issue. So Practical Compliance Guidance, that's 2019-5. So generally there's a safe harbor of an extra 18 months if certain safe harbor conditions are met. For example, if there's a Part 4 challenge to the will, a life tenancy delays the disposal, if the complexity of the estate results in a delay, if the settlement contract falls through for reasons outside of the control of the taxpayers, COVID-19 restrictions, so forth. So generally there's a safe harbor in those circumstances of another 18 months. And beyond that, you'd actually have to apply for an exercise of the Commissioner's discretion. So there is a lot to that main residence exemption. I've only looked at one aspect, well, a few aspects of it, but in the context of that particular provision, which is what most people think of in terms of the main residence exemption. So just to recap in terms of what we've covered in terms of tips and traps. So we've looked at, firstly, deeds of family arrangement. We then looked at later acquired assets by an LPR of a deceased estate or a trustee of a testamentary trust. Thirdly, we looked at foreign resident LPRs and trustees of testamentary trusts. Fourthly, we looked at tax advantage beneficiaries. So we looked at CGT event K3. Fifth, we looked at the concessional taxation for 3 years. Then we looked at the small business CGT concessions, which hopefully I've explained reasonably clearly enough. And finally, we looked at the main residence exemption. So that's it from my end, wrapping up part 1. And now I'm going to hand it over to Katerina for part 2, case studies and recent cases.
Thanks so much, Archie. That was actually really succinct sort of cover of the relevant tax points when we're doing estate planning. Please feed your questions through to Archie. There'll be time at the end for some questions as well. So if you need a few moments to sit on them and think about them, Archie's also able to be engaged directly outside of obviously this presentation. So feel free to send through your questions if they come up. Katerina, your turn to talk all things death and taxes. I'll just get your slides up here if you want to go into presenter mode. This little one down the bottom here,
says it's working. Can you go I'm gonna look
so we can see the slides. It's not in presenter mode. You know when you press the presentation?
Okay. So I do that on the PowerPoint, not in Streaming.
Down the bottom right-hand corner of PowerPoint, you'll see there's a little sliding scale. Can you see that on the bottom of PowerPoint? Bottom right-hand corner.
No. Is that working?
No.
Okay. Exit full screen. So this slide, do I press slides?
No. Are you on your PowerPoint screen, lovely?
Yes.
Yeah, so down the bottom right-hand corner at the very bottom, you'll see there's a little sliding scale. Can you see that? That's it. And press the little button. That's him. So press that.
Does that work?
No, and then you might have to then go to share the correct screen. You might be sharing a different screen if you're using more than one screen.
Sorry, everyone. Okay, I'll have to stop. It says I'm sharing the slides.
That's okay. Listen, let's share them as they are, and then...
okay, because I think everyone can see that.
Yeah.
The only thing I can think to do is...
potentially zoom on the screen. No, still the same.
Still the same, okay.
Yeah. See how we go. Let's work with what we've got.
Right, let's work with what we've got, yeah. So just the usual lawyer disclaimer. Okay, so I'm not a tax lawyer. I don't really, I can't quote sections the way Archie, being a tax lawyer, can. I just try to remember the principles and then identify it for the tax lawyer that I refer to or the accountants that I refer to. And so these are some of the things that have happened on our files, and I can't take any credit for the advice that we received. All that happened was I thought there might be this issue. We sought advice, and this is the outcome that occurred. So in this case, we had Mary, who lived to, she was 95 or 96. When she died, she lived in an extremely run-down shack. I think it had a toilet as an outhouse, but eventually got rezoned as residential. And so by the time these 7 hectares sold after her death, we were able to get 15 million for it. And I think they're building a residential care facility on that block now. It's just on the outskirts of Melbourne. So the rule is that she lived on that property for a very long time. The main residence exemption applied to the dwelling, so to her house, to her garden, plus we could choose an extra sort of 2 hectares of adjacent land that we could apply the exemption to. So out of the 7 hectares, 2 were going to be exempt from capital gains, and the other 5 were going to be taxable. So I'm going to show you a picture. So this is actually her block. This is out in Hallam, somewhere in on the outskirts of Melbourne. So you can see where the house is. It's that white thing, kind of in the middle of the block. Right, so we had to choose 2 hectares, but we were able to move in whichever direction we wanted to. So we didn't, I don't know if you can see my cursor. So we didn't have to go, okay, that's the house and we're going to go exactly round it like this. We could choose to go 2 hectares this way or this way, whichever way we wanted to. And as it happened, this bit of the land was actually far more valuable than the back of it. This is the main road. There was drainage, there was parking. It was great. So we moved. We chose to for the exemption to cover 2 hectares going kind of like, and I should have drawn this earlier, but it kind of like this. We got the entire Princess Highway frontage, bit of a, veggie garden, and her house. So this is the reference in the tax legislation, and the only rule that applies to these 2 hectares is that the 2 hectares, they weren't used for income producing purposes. It was adjacent to the house, and she used it for her private or domestic purposes. So she had some sheds there. There's a veggie garden, a rose garden. That's what we were able to grab. So that's that again. Okay, and this is the same case. So as it happens, this land was actually on 4 different titles. She acquired different titles at different points in time. Some of it she got by adverse possession. That's how long she'd been there. So what happened was this ended up quite a large estate. And she divided it 6 ways between some friends who helped her to stay independent on this very large property. And one of the beneficiaries was a hospital. It was, and I can say this because the hospital has put up a huge plaque in her name. It's the if any of you know, St. John of God in Berwick. So the hospital was entitled to a sixth of the estate, and the estate was sort of 15 million plus other bits and pieces. What we realised was that the hospital was a tax exempt entity. It doesn't pay income tax on its earnings, and what we were able to do was we were able to make the hospital specifically entitled to the capital gain on the more valuable parcels of this property. So we were only able to do that to the extent of its 1/6 entitlement, but whatever we were able to fit into that 1/6, there was no capital gains tax payable, which enlarged what everybody else could inherit. So the basic CGT, just on a basic calculation, if we didn't use the hospital as a tax exempt entity, it was around 300,000. And the way we were able to kind of direct the capital gain towards the hospital, we ended up with a tax bill of 20. What we had to do to be able to do that, apart from get really technical, complex tax and accounting advice, we had to make the hospital specifically entitled to the capital gain before 31 August. So the sale went through in April. In the financial year, end of June, we had to exercise that right, or this rule. We had to record it and exercise it by 31 August. And we also had to notify the hospital of this before 31 August, get their consent, which is what we've done. And the hospital was obviously very happy to cooperate, as were the other beneficiaries. So that was a huge tax saving for the estate. And I think that, I'd heard about Bamford. I'd done some resolutions for Bamford. I knew we could kind of direct some stuff to some beneficiaries. I didn't know this rule very well, but I was just able to ask the right question, and the accountants guided us the right way. Okay.
Just to give you a break there, Katerina, to catch your breath, I think that's a really good point that you've just made there, is that as practitioners, we're not expected to know everything all the time. I think that we have to have little flags that go up in our brains for things that are potential issues, but then really we should be working collaboratively with other people to find the answers or find the best solutions for clients. So I think that's a really good point. And for those that don't know, Katerina's pretty up there in terms of her skills and professionalism. So if she's saying she didn't know, that's a pretty brave thing to say, Katerina. And I think it just goes to show that even people at the top of their game, they recognise which lane they know, and they know well, and then you reach outside of that when you need that extra assistance.
Yeah, and tax is it's a thorn in my side. I worry about it all the time. So whenever we give a brief to the accountants or tax lawyers, we always put at the end, if you see anything that we haven't identified, please tell us. This is only what we've seen. You might be able to see more. So we never kind of limit their scope to just the questions we're asking. And sometimes we've had some really surprising stuff come back. Okay, so the next one is this, and I'm sorry these are so small. I'll have to practice for next time. So this is something Archie discussed earlier, but this was just kind of, it just got messy, and I wanted to bring it up so that it's at forefront of everyone's minds. So, and I only came into this towards the end, otherwise I'd like to think it wouldn't have been this bad. So Sandra did a will, almost 25 years ago, nominating her 2 sons as executors. Fair enough. 10 years later, the sons go to work overseas. One goes to Hong Kong, one goes to the US, and they don't come back. 10 years later, 2020, she dies. It's the height of COVID. Melbourne's in lockdown. They don't even make it back for the funeral. It's bad. The estate's about 3 million. We've got a really beautiful Mornington Peninsula property where Sandra lived, and then a share portfolio that was her source of income. The sons get probate in 2021. I'm not involved at this stage. They come to me a little bit later once they get stuck with the shares. So the rule is that the executors step into the deceased's shoes from the moment the person dies. So when Sandra died in 2020, her executors stepped into her shoes, but her executors are non-resident. So from the minute they stepped in, the estate became a non-resident estate, okay? And what that means is that the estate it's taken to have disposed of all of its assets at date of death. So it's as if those assets have been taken out of Australia and they've gone overseas. Okay, so it's a CGT event. And what that means is that even though we hadn't disposed of the shares in 2020 or 2021, we didn't dispose of the shares until 2 years after Sandra had died. The CGT event occurred on her date of death as if the shares had been sold for market value. So we still had the shares. We didn't have the proceeds of sale, but we had a debt owing to the tax office. So we got some advice, and what we needed to do was we needed to sell the shares in order to be able to pay the tax, because we had no cash in the estate. And then there was a second CGT event when we did sell the shares, and the complex advice came around to try and have the CGT reduced to the extent that the disposal at date of death versus disposal now. I can't actually tell you how it worked, but there were quite complex calculations to try and reduce the tax. What was the cost base of the shares in 2022? How do we, finding the right date to sell the shares so that the tax wouldn't exceed the benefit. And we had there was no CGT discounts available because it was a non-resident estate. So there was quite a lot of tax to pay there. We also had to get advice as to what happened to the main residence. So luckily the real estate is exempt from this particular CGT event. So no CGT event occurred at date of death. The CGT event occurred when we sold the property, and we were able to, that the main residence exemption was available to us. But, this is, 15 grand worth of accounting and tax advice, lots of worry for the two sons. All Sandra had to do, and she actually had, 10 years to do it, she just had to change her executors. She needed, one or two Australian executors to support her sons. The sons could have stayed on as executors. She just needed to have some Australian people representing, some Australian people as executors, Australian residents as executors together with her son to make this a resident estate. And all of this could have been avoided. I mean, the administration took, 3.5 years. We're just winding it up now. So that was a really easy one to avoid. Okay, next one. Next one is Simon. So Simon studied engineering and science at Monash. He did honours. He did a PhD. He had a massive HEX debt by the time he was done. And as it happens with these highly skilled individuals who do really well at uni, he got headhunted and he went to work in Dubai, where he worked for 5 years for some oil corporation. He was single. He didn't have kids. His mum and dad were quite elderly. They were here in Melbourne, and he kept coming back, at Easter and Christmas to visit them. But he didn't have a residence here. He lived in Dubai, and he lodged tax returns in Dubai. 2020, again, height of COVID, he dies in a car accident. And again, really traumatic. Parents couldn't make it out there. It took us 9 months to get the body back to Melbourne. It was really, really awful. So he's lodging tax returns there. He's non-resident for Australian tax purposes from 2015. So there's 5 years that he's not lodging tax returns, not paying tax here. There was no will, and the parents were entitled to his estate. So here's the issue. The issue is that, so he leaves 2015. He probably didn't have any income at the time. He's straight out of uni. He's not really, very familiar with tax rules. Halfway through his stay in Dubai, the rules change, and they say that non-residents, for tax purposes, who have a study loan debt here in Australia must report their worldwide income to the ATO so that they can pay down their student loans. So, and Simon wasn't doing that. He I don't know whether it was deliberate or he just didn't know, but when he died, there were no Australian tax returns done here to report his worldwide income. And he shouldn't have been paying tax on his worldwide income. All he was supposed to be doing in those Australian tax returns is paying down his student loans. So we had to do all of the outstanding returns. The rate of repayment is higher for non-residents, and there's also an extra levy that non-residents pay. So in his final tax returns, the 5 tax returns that we had to do, he basically paid down $63,000 off the $65,000 debt, and we had to use his overseas money. There was no money in Australia. We had to use his overseas assets to satisfy this debt, and all that was extinguished by his death is the $2,000. So death extinguishes student loans. It's not a debt that carries through to your estate. And interestingly, and I just put that there because I only learnt that last night, but student loans are not extinguishable by bankruptcy. So you can go bankrupt, get cleared, all your other debts will clear, but not your student loans. So, and again, this took a very long time to wind up. It's actually still going. We're still trying to collect some bank accounts in Dubai.
These are not very happy stories, Katerina, are they?
They never are.
I'm not ready for this sort of trauma on a Thursday.
No.
I think we're already struggling under the debt of student loan repayments, so to hear this is a bit upsetting and maybe a bit of a catalyst for some of us to get out and do something.
Okay, well, the next one's even heavier and probably even more stressful. So FIRB, which gives lots of people in this space a lot of anxiety. It's not very well understood. And for a while, I was thinking that, I'd kind of read the basic rules and I thought, oh, good, I can just ignore this. This isn't going to apply to most of what I do. But as it goes, in 2021, they changed the rules and it now applies to deceased estate. So in the past, if you had a beneficiary under a will or intestacy or whatever inheriting land, so a non-resident beneficiary inheriting land, you didn't really have to worry about FIRB. From January 2021, foreign beneficiaries under a will have to get FIRB approval in order to inherit. Okay, and it doesn't make sense to me, but LPR, so executors, administrators of deceased estates, they don't need FIRB approval to put the land into their name and to, administer it in accordance with the will or intestacy. So non-resident LPR don't need FIRB approval. Non-resident beneficiaries on intestacy don't need FIRB approval. It really is just, I know, it is just beneficiaries under a will. Okay.
Hold on. I just need you to repeat that, Katerina, for us who are sitting in here a bit of shock.
So non-resident.
If you're a beneficiary under a will, it applies. If you get it by intestacy, it doesn't.
That's right. Because
we're going to need to go get the chocolate cake out of the fridge, I think.
So it says that it doesn't apply to those transfers that devolve by operation of the law. So LPR taking a transmission of real estate, that devolves by operation of the law. Intestacy is operation of the law. Receiving under a will is not operation of the law. It's a person exercising testamentary freedom. So it's real, like it doesn't make sense, right? So the beneficiary under a will, they have 30 days to make the application to seek this approval, not from the date that, the transfer is made, not from, it's a really nebulous concept. It's from the day when they acquire a legal interest, which is, probably, the day that the executor determines they no longer need this asset for the purpose of estate administration. So from the date of assent. But really, that date is often quite difficult to ascertain, and it puts the onus on the executor to say to the beneficiary, hey, I'm done. I haven't put it into your name. I haven't done, tax returns or whatever, but you've now got 30 days to make the application to FIRB to get approval to inherit this property. The application form for approval is really complex. I had a look last night, and I'm literally praying I don't get an estate like this. I've got one on the go, but I'm trying to convince them to just sell the property in the estate so they don't have to worry about all this stuff. It's a really complex application. It's not a lay down misère that you're going to get approval. The criteria for getting approval is really complex, and it's also not, I don't understand it. You will be given approval if your acquisition is not contrary to, where's the wording, is not contrary to Australian national interests, security, competition. And what they're going to look at the character of the recipient. They're going to, I assume that someone like Putin won't be able to acquire land in Australia. Maybe Zelensky either, I don't know. They will look at what you're going to do with the land. Are you going to rent it out? How are you going to treat your tenants? And there's some examples actually on the FIRB website about, that how they're going to require you to store data, how you'll communicate with your tenant, who's going to be your intermediary, how you're going to store data relating to this property. So it's a real really serious process. The application fee is also pretty serious. It's based on value of the property, and it's just as a rough guide, it's like $14,000 for every $1 million market value of the property, and it's payable by the beneficiary before they've inherited it. And they don't have certainty that they're actually going to be able to retain the property. So FIRB can, to get you over, if you make the application and you don't, it's not in national interest to let you have the property, there's all sorts of conditions that FIRB can impose, and they're going to monitor your compliance with those conditions. There are significant penalties for failing to make the application, for kind of going behind FIRB's back. So the easiest thing to do is just to sell the property. But if you don't end up, yep.
No. Just to let you know, there's lots of questions coming through over here.
Lots of questions coming through. Yeah, I've realised I've just got 5 minutes left, so
I'm conscious of time.
Yes.
I also think for those that some of the questions might actually be answered on, Tara has a training about this specific topic as well from an estate planning perspective. I encourage anybody that is using Tara's precedents to have a look at that training, because some of those questions that are being asked will actually be answered. But Katerina, if you wanted to, you can probably see some of the questions over here. One of the...
Are they all FIRB related questions? Because I'm probably done with FIRB. I've got one other topic that I wanted to cover quite quickly. Do you want me to deal with the FIRB questions?
That's fine. Pop FIRB aside, because we can either take...
I'll leave that to Tara. Tara probably knows a lot more about it than I do.
And most of the people that are asking questions are in the TT Precedents Club.
Okay, cool. I'm very happy to leave that to Tara. Okay, so I'll just speed through. I'll speed through the other slides that I've got. This is probably sort of recent developments, what's been happening. So there is every second case that I read seems to be about accountants and lawyers not having kept, and I'm not talking about clients, we don't expect anything of clients, but accountants and lawyers having not kept proper records, done documents from precedents without having actually reviewed this very specific rules that apply to the different entities that they're dealing with. So everyone's probably heard of RIOEs in the Supreme Court down here in Victoria. It's gone on appeal 2 or 3 times. Legal costs are in the millions, okay? But how it started is there were deeds of variation that were just templates that didn't relate back to the actual original trust deed that set out very clear rules to follow for preparation of variations, deeds of succession, deeds of appointment. There was a long-term lawyer who'd acted for the family for 40 years. There was a long-term accountant who acted for the family for 40 years. There was the records were really poor. Some of the records appeared contrived. It wasn't clear whether they were done at the time or later, or kind of someone filled in the gaps at some point, over the course of the 40 years. The people who were meant to have signed minutes or resolutions or deeds weren't signed in the right order. They weren't properly dated. There was confusion as to whether people were signing as principal or as director of the company. There was a question as to validity of, the changes, the resolutions to distribute income. And really all it came down to is this really poor record keeping and really poor knowledge of the fundamental documents that created these entities. The same thing happened in this case, which is in the federal court. This was a really big decision. So RIOEs arose out of mum and dad dying and the 3 children having a big fight over what's in the estate, who's going to get what, who's going to control what. And this is just going to keep happening more and more. This one didn't come out of a deceased estate. This one is a dispute between the ATO and the taxpayer as to whether he should pay, in the hundreds of millions in tax, or whether there was an exemption, because the paperwork wasn't clear as to who was the owner of units in a unit trust. I mean, that's ridiculous, right? You're operating an entity that's worth, several $1 billion, and you don't have proper records as to the true owner of the assets. I'm speeding through. This one also arose out of death of very, very elderly mum and dad. And it was a question as to who the trust vests in, who takes the assets of the trusts. There was the trustee company was established after the trust was set up, even though it was named as a trustee on the trust deed. The property was purchased in the name of the people who were going to be directors of the company, but the company hadn't been established. Anyway, the property was listed in the financials, but then there were different people signing for the ownership of the property. And in the end, the court found that the trust had actually vested years ago. It didn't vest now when mum and dad died. It vested years ago. So this was 2 daughters trying to work out what was in the estate. And again, it came down to the accountants not being able to give good evidence of what happened. This is just a couple of months ago. I'll just mention this one really quickly. This arose over a self-managed super fund that was established in 1979, and no one could work out whether the self-managed super fund, which was very valuable, had over $1 million worth of assets, whether it was still in existence, who was the trustee, and whether the nomination was valid. And really what was happening was that there were several changes in trustee over the years. The documentation wasn't signed properly. Sometimes it was undated. Sometimes only one of 2 or 3 people would sign. Sometimes people signed as if they were individual trustees rather than directors of a company. The common seal wasn't applied. Documents were missing. Some documents were found between a stack of carpet tiles at the lady's home. Some were in the kitchen cupboard. The accountant couldn't give evidence because he himself had dementia and had gone out of business. Well, he'd sold his business to someone else. So there was no sort of SMSF paper file that someone retained with all the resolutions. All of that was missing. So that's a good one to read, actually, of how the court went through the process of regularising the actions that had been taken by the trustee, over a 30-year period to determine that, yes, there was a trust deed, wasn't signed, it's dated 2015, that's probably what happened. And the last one I'll mention is this one, very similar. This is just a month ago down here in Victoria. The legal costs in this one for both sides were over $800,000, okay? And it was essentially a dispute as to whether dad or the husband owned the property or whether the property was in a trust. And again, the deed wasn't dated. The deed was dated, but it was dated before instructions were given to a solicitor to set it up. There was missing documents as to trust operations. It hadn't filed proper notifications with ASIC. Anyway, the same sort of story. Sometimes clients come in and give you a trust deed and you grab that and we work with that. But I think what all of these cases are pointing to is that we have to say, what other documents do you have? And it's so easy to do that now, just store it electronically. Grab those documents, store them on your file, have a complete history of the documents for any trust or any self-managed super fund, supervise the execution, keep copies of the executed documents, make sure people know in which capacity they're signing, sign the documents on time, date the because a lot of this was just approaching the court for a court to determine what was what. It wasn't a dispute about, valuations or existence of an asset. I just think these are so easily avoidable if we just keep a record. Give proper instructions to the client how to do something and keep proper records. I'll finish now because
Katerina. No, that's so good. It's so true, though. Proper records is probably one of the biggest issues that pulls apart a lot of different things. So yeah. It's a good reminder for us that that's something we have to keep an eye out for. Thank you so much, Archie and Katerina, for sharing your knowledge with us today and giving us your valuable time. If anybody has any questions that they want to ask Katerina or Archie, please feel free to take those offline, and the lovely ladies will be able to help you as they're able to. In terms of where we go to from here, as I said, there's a couple of trainings that Tara has mentioned in the chat. So anybody still looking for information, please read the comments from Tara and then loop back into the training available through the Art of Estate Planning. Otherwise, I want to wish everybody a wonderful week and looking forward to seeing you all again next month on the Art of Estate Planning Facebook Live. Thank you very much.
Thank you. Thanks, Carrie.
Thank you.